Hello everybody, welcome to iExamB's Legal B. This is Amrita, your law faculty here at iExamB. Embrace the iExamB learning experience with us. In case of any queries, you can reach out to us by writing us an email on hello@iexamb.com. आप हमें कॉल कर सकते हैं directly on the number 9205524028. Visit our website www.iexamb.com for all the details relating to online courses. And this is our YouTube channel Legal B, स्पेशल लॉ चैनल ऑफ iExamB. इस पर आपको लॉ से रिलेटेड सारे अपडेट्स मिलते रहेंगे, लीगल कोर्सेज, कंटेंट, स्ट्रैटेजिक प्रिपरेशन वीडियोस, एवरीथिंग यू कैन गेट एट वन प्लेस ऑन लीगल बी. सो डोंट फॉरगेट टू सब्सक्राइब. आज के इस वीडियो में हम लोग डिस्कस करने वाले हैं अबाउट द प्रीवियस ईयर पेपर ऑफ 2023 और सेबी ग्रेड ए लीगल ऑफिसर एग्जामिनेशन. This paper is going to be of the first phase paper 2, that is the legal paper. इसमें से मैं कुछ MCQs डिस्कस करने वाली हूँ. I have divided this into two parts. Today I am going to discuss first 25 MCQs in this video, that is the part 1. Next 25 मैं अगले part में, that is part 2 में cover करूँगी. ये सब memory based paper में से लिया गया है. memory based paper जो कि previous year paper होता है for SEBI grade A legal officer examination. Let me tell you some things about SEBI grade A selections that have been from iExamB. More than almost 50% selections have been from iExamB. These are the students of iExamB who have been selected as SEBI grade A legal officers in 23-24. SEBI grade A legal online course is available at iExamB. आप ये सारे डिटेल्स चेकआउट कर सकते हैं एंड इमीडिएटली एनरोल भी कर सकते हैं. इसी नंबर पे आप कॉल करके सारे डिटेल्स को ले सकते हैं. सो दिस इज द नंबर ऑफ सेलेक्शंस दैट हैव बीन फ्रॉम iExamB in SEBI continuously in 22, 2020, 22, 23 and onwards. The first question. Article 14 of Constitution of India is related to equality before law, equal opportunity of employment, abolition of titles, removal of discrimination, freedom of expression. So this is a very simple and straightforward question from Constitution of India, Article 14. Correct answer is A, equality before law. State shall not deny to any person equality before law or equal protection of laws within the territory of India on the grounds of religion, race, caste, sex or place of birth. Article 18 of Constitution of India is related to equality before law, equal opportunity of employment, abolition of titles, removal of discrimination, freedom of expression. So Article 18 की अगर हम बात करें तो वो किससे रिलेटेड है? ये भी काफ़ी सिंपल एंड डायरेक्ट क्वेश्चन है. abolition of titles except military and academic. You cannot make any kind of discrimination on the basis of titles. Article 21A of the Constitution was added to free and compulsory education to children of age of 6 to 14 years. All children of the age of 6 to 14 years. Free education children of the age of above 6 years. Free education below the age of 15 years. Compulsory education to be provided by the states. So 21A is an amended article in Constitution. ये क्या provide करता है? That has been specifically added. This is a part of fundamental rights. So the correct answer is A, free and compulsory education to all children of the age of 6 to 14 years. No person shall be deprived of his life or personal liberty except according to procedure established by law. This is provided under which article of the Constitution? Very simple and direct question. इस तरीके के जो questions होते हैं काफ़ी स्कोरिंग होते हैं. So आप लोगों को नोट डाउन करना है कि इस तरीके के अगर क्वेश्चंस आते हैं एग्जाम में, सो यू हैव टू बी वेरी मच प्रिपेयर्ड फॉर इट एंड नॉट लूज मार्क्स इन सच काइंड ऑफ क्वेश्चंस विच आर वेरी डायरेक्ट. सो द करेक्ट आंसर इज बी, आर्टिकल 21. Article 21, as you can see, the wordings that have been asked in the question are directly taken from this. Protection of life and personal liberty. No person shall be deprived of his life or personal liberty except according to procedure established by law. Article 129 of the Constitution states that the Supreme Court shall be a court of dash and shall have all the powers of such a court, including the power to punish for contempt of itself. So this is what are the wordings of Article 129. इसमें से कुछ words missing है, एक ही word missing है actually, वो आपको इन options में से देना है the correct answer. A very common and important article this is. Correct answer is record. Court of record. What is the meaning of this court of record? Supreme Court is the court of record, and because of being the court of record as per Article 129, it is having the powers to include the power to punish for contempt as well. All the judgments given by Supreme Court are maintained as a record and are used as judgments as being binding on all the courts within the territory of India. Name of states and union territories are given in first schedule of Indian Constitution, second schedule, third schedule, Government of Union Territories Act 1963, State Reorganization Act 1956. Correct answer is first schedule of the Indian Constitution is providing for the list of states and union territories and their extent and territorial jurisdictions. Provisions of separation of judiciary from executive is given under Article 48, 50, 42, 51, 48A. Separation of judiciary from executive specific article है Constitution में. It has been asked कि ये कौन से article के अंदर दिया हुआ है. Important provision है. It is even a part of basic structure of the Constitution. Correct answer is B, Article 50 of the Constitution. Governor of the state may dash entrust to state government or to its officers functions in relation to any matter which the executive power of the state extends with the consent of President, consent of Government of State, Government of India, on his own, on the directions of central government. So Governor of State ये सारी चीज़ें किसके direction पे कर सकता है, किसके consent पे कर सकता है, that has been asked. Correct answer is C, with the consent of Government of India. Article 258A of the Indian Constitution talks about it. Total number of Council of Ministers shall not exceed 15% of total number of members of the House of People, excluding Prime Minister. Same thing, including Prime Minister. Not exceed 12%, including Prime Minister. Not exceed 15% of total number of members of House of People, excluding Prime Minister. Not exceed 10% of total number of House of People, including Prime Minister. So the correct answer is D, not exceed 15% of total number of members of House of People, including the Prime Minister. Article 75 of the Indian Constitution directly provides for this. 75(1)(a) ये भी एक amended provision है and यहाँ से भी questions आ सकते हैं. Not exceed 15%, आपको ये याद रखना है 15% है, and ये भी याद रखना है कि उसमें Prime Minister included है. Consensus ad idem means same idea, consent on same idea, meeting of the minds, same opinion on contract, similar consent on contract terms. Very very common phrase, very important one from contracts. This means meeting of the minds. It is mostly used in contract law and refers to the fact that there is an agreement among the parties to the contract. It simply means that there exists a mutual agreement among all the parties to a contract. Which of the following terms is related to friend of the court? Amicus curiae, ejusdem generis, bona fide, actuary incumbent, ad hominem. So friend of court ये भी काफ़ी कॉमन लैटिन टर्म है, मैक्सिम है. इसका मीनिंग है amicus curiae, which means friend of the court. एंड ये एक इंडिपेंडेंट इम्पार्शियल एडवाइज़र होता है जो कि कोर्ट अपॉइंट करता है in different matters for seeking opinion, research, assistance and so on. This is a third party or an independent person. Latin maxim obiter dicta means things said specifically, things said by the way, specific order declared by the court, obligation dictated by the court, dictation given by the court. So obiter dicta means what? Things said by the way. Obiter dicta, ratio decidendi, ये काफ़ी important terms है. These are two parts of a judgment. Ratio decidendi talks about the reasoning part of judgment. And obiter dicta talks about the by the way sayings of a judge. जो भी चीज़ें या comments या opinion कोई judge देता है while he is delivering a judgment, That is known as obiter dicta. So they are not directly binding because they are not the reasoning part, but they do have value, especially the obiter dictums of Supreme Court. The term corpus delicti means body of the crime, deceased person's body, decomposed body, criminal decision, decision based on corpus. So corpus delicti भी एक important Latin term है. What is the meaning of that? A. Body of the crime. Corpus delicti is a Latin term meaning body of the crime. It is the essential facts that prove that a crime has been committed. Doctrine of corpus delicti is the requirement that state proves that a crime has been committed prior to allowing confession to be admitted into evidence. Which of the following term describes infringement or violation of legal private right of any person without any actual loss or damage? Sine injuria, injuria sine damnum, volenti non fit injuria, actus Dei nemini facet injurium, ex injuria just non purisher. So इनमें से कौन सा टर्म है या मैक्सिम है जो इसके बारे में बताता है? The thing that has been asked in the question is the meaning of which maxim. This is also very common one. Answer is B, injuria sine damnum. Maxim injuria sine damnum means what? Infringement or violation of a legal private right of a person, even if there is no actual loss or damage. In such a case, the person whose right is infringed has a good cause of action. He does not have to prove any special damage for that. When a list of specific words are being followed by the general words are interpreted in a way dash to the specific words. Mutatis mutandis, ejusdem generis, non obstant, ratio decidendi, obiter dictum. Correct answer is ejusdem generis. ये भी interpretation of statutes का एक rule है. And ejusdem generis actually means it is actually a doctrine which says that when some specific words are being followed by the general words, and if there is any ambiguity in the meaning of the general words, then the doctrine of ejusdem generis is applied, which says that the general words following the specific words will be restricted to the same class of specific words. यानी कि उनका जो मीनिंग होगा वो स्पेसिफिक वर्ड्स के एंगल में लिया जाएगा. जनरल वर्ड्स का जो मीनिंग होगा अगर उसमें कोई एम्बिग्यूटी है तो, नहीं है then it can be having obviously only one meaning. But if there are two possible meanings, three possible meanings, then you have to give the meaning according to the associating words, which are the specific words. Any fault, imperfection, shortcoming or inadequacy in the quality, nature and manner of performance, which is of a contract or otherwise in relation to any service, is called as defect, defective goods, deficiency, defective service, warranty. Now you might feel ये कहाँ से question आ गया? Contracts हो गए, constitution हो गया. Now this question is from Consumer Protection Act. This is a mixture because ये previous year paper है, इसमें काफ़ी सारे subjects covered है. Consumer protection is also an important topic. From that, the correct answer in this question is deficiency. Answer is C. Section 2G of Consumer Protection Act talks about the meaning of deficiency. This is the actual meaning of deficiency. Thou art to be hanged not for having stolen a horse, but in order that other horses may not be stolen. This is the theme of Doctrine theory, doctrine of societal personification, doctrine of correctional vengeance, retributive theory, preventive theory. So ये किस theory का theme है? Correct answer is A, deterrent theory of punishment. Deterrent comes from the word deter, which means aims at preventing criminals or individuals from committing the offense of any crime. This keeps in mind that an individual probability of committing any crime in future is lowered, and it will generate a fear in their minds so that they are aware of the consequences of their criminal act. So deterrent theory of punishment is a utopian idea. This can be understood in the words of Dr. Bennett J. उनके words में भी ये theory समझी जा सकती है. Whoever intentionally uses force to any person without that person's consent in order to cause injury, fear or annoyance to the person is said to cause assault, battery, criminal force, assault by force, force. Correct answer is C, criminal force. Section 350 of IPC deals with the definition of criminal force. Criminal force, assault, battery, ये सारे जो terms हैं इनमें जो स्पेशली द थिन लाइन ऑफ डिफरेंसेस हैं और जो नेसेसरी इंग्रेडिएंट्स है वो आपको समझना ज़रूरी होगा. सो अकॉर्डिंगली यू हैव टू आंसर द क्वेश्चंस विच आर कमिंग फ्रॉम दीज एरियाज. इन IPC, in criminal law, remember always you have to remember the ingredients of the offenses. Okay. Jurisprudence is a Latin term which means knowledge or subject of study of law, interpretation of law, rule of law, procedure established by law, justice. So this is a Latin term which is meaning what that has been asked. Very simple question, बहुत basic question है, jurisprudence से हमेशा आता है. Correct answer is A, knowledge of law, study of law. The word jurisprudence is the English derivation of the Latin word jurisprudentia. Translation of the word means the study, knowledge or skill with regards to the law. According to Salmond, jurisprudence is the body of principles recognized and applied by the state in the administration of executive, administration of justice, pursuit of justice, enforcement of sanctions, regulation of conduct. So according to Salmond, jurisprudence is the body of principles that are recognized and applied by the state. But for what purpose it is recognized, that has been asked. It is recognized for, answer is B, administration of justice. According to Friedman, this is what is the definition. According to Duggett, this is the definition. According to Parker, this is the definition. And according to Salmond, law is the body of principles recognized and applied by the state in the administration of justice. So अगर हम jurisprudence की बात करें तो definition of law, definition of what is jurisprudence, ये सब बहुत ही basic चीज़ें हैं. अगर jurisprudence से कभी कोई question आएगा तो कभी भी आपको definitions, theories, इन सब चीज़ों से ही ज़्यादातर पूछा जाएगा. इसमें सालमंड एक काफ़ी फेमस फिलोसोफर है. Where the prescribed period for any suit, appeal or application expires on a day when the court is closed, the suit, appeal or application may be instituted or made the next day, on the day when the court reopens, on the day when the court resides, on the same day next week, on the day when the parties decide. So correct answer is B, on the day when the court reopens. Common sense भी अप्लाई किया तो भी आप ये क्वेश्चन आंसर कर सकते हैं. एंड वैसे तो ये लिमिटेशन एक्ट में कवर्ड ही है. सेक्शन 4 इन द लिमिटेशन एक्ट टॉक्स अबाउट एक्सपायरी ऑफ प्रिस्क्राइब पीरियड व्हेन द कोर्ट इज क्लोज्ड. एक्सप्लेनेशन क्लॉज देखोगे अगर तो कोर्ट शैल बी डीम्ड टू बी क्लोज्ड ऑन एनी डे विद इन द मीनिंग ऑफ द सेक्शन ड्यूरिंग एनी पार्ट ऑफ इट्स नॉर्मल वर्किंग आवर्स इट रिमेन्स क्लोज्ड ऑन दैट डे. तो जैसे ही रीओपन होगा वहाँ से आप कैलकुलेट करोगे. Where the prescribed period for any suit, appeal or application expires on a day and the court is closed, then the suit, appeal or application may be instituted or made. Next day, on the day when the court reopens, the day when the court decides, on the same day next week, on the day when the parties decide. So correct answer is B, section 4 के हिसाब से. ये क्वेश्चन लिमिटेशन एक्ट से ही है, ये दोबारा से आ गया है, बट दिस इज द सेम थिंग विच आई हैव ऑलरेडी डिस्कस्ड. सेक्शन 4 इन द लिमिटेशन एक्ट टॉक्स अबाउट दिस. व्हाट इज द लिमिटेशन पीरियड फॉर अ सूट बाय अ मॉर्गेजर टू एनफोर्स पेमेंट ऑफ मनी secured by a mortgage or otherwise charged upon immovable property. So now they have asked you a question from limitation period, and what it is specifically, it is talking about a suit by a mortgagor to enforce payment of money that is secured by a mortgage or otherwise charged upon the immovable property. 3 years from when the money suit becomes due, 2 years when it becomes due, what? The money suit, the principal money. 1 year when the money suit for becomes due, 12 years from the money suit becomes due, 30 years when the money suit becomes due. So कब से कैलकुलेट होगा? प्रिंसिपल मनी जब से ड्यू होगा तब से ही होगा, बट द years I have been asked basically. Correct answer is D, 12 years from when the money suit becomes due. Article 62 of the Limitation Act talks about it. ये शेड्यूल में सारे पीरियड प्रोवाइड किए गए हैं. अब यहाँ पे अगर हम बात करें तो आप सोचोगे कि हमें कौन से सूट्स के बारे में पढ़ना है. तो अगर कोई बहुत ज़्यादा इम्पोर्टेंट सूट्स है, जैसे यहाँ पे मॉर्गेज से रिलेटेड है, सो दे हैव आस्क्ड यू क्वेश्चन स्पेसिफिकली फॉर मॉर्गेज. इस तरीके के जो लैंडमार्क सूट्स हैं या एप्लीकेशंस हैं या अपील्स हैं, आप उनके अगर शेड्यूल में से लिमिटेशन पीरियड्स याद रख सकते हैं, देन दैट इज़ वेल एंड गुड फॉर यू. द लैंडमार्क वंस. Where the mortgagor ostensibly sells the mortgage property on a condition that on default of payment of mortgage money on a certain date, the sale shall become absolute. That is called as usufructuary mortgage, simple mortgage, mortgage by conditional sale, annualist mortgage. Ostensibly sell, ये कौन से मॉर्गेज के टाइप में कवर किया जाता है? मॉर्गेज के सारे टाइप्स आपको पता होनी चाहिए फ्रॉम टीपी एक्ट. दिस इज द मोस्ट इंपॉर्टेंट क्वेश्चन. एंड उसमें ऑस्टेंसिबली सेल कौन से टाइप का पार्ट है? हर एक टाइप की अपनी अपनी पेक्यूलियरिटीज हैं. वी टॉक अबाउट मॉर्गेजर ऑस्टेंसिबली सेलिंग द मॉर्गेज प्रॉपर्टी ऑन अ कंडीशन दैट द सेल विल बिकम एब्सोल्यूट इन केस ऑफ डिफॉल्ट ऑफ पेमेंट ऑफ मॉर्गेज मनी बाय द मॉर्गेजर. दैट इज मॉर्गेज बाय कंडीशनल सेल. सेक्शन 58 में मॉर्गेज बाय कंडीशनल सेल का वर्ड है. दैट इज कवरिंग ऑस्टेंसिबली सेलिंग द प्रॉपर्टी. लास्ट क्वेश्चन फॉर टुडेज डिस्कशन. Suit to obtain a decree that a mortgagor shall be absolutely debarred of his right to redeem the mortgage property is called suit for foreclosure, redemption, sale, possession, mortgage. Now this is a very logical question. If it is debarring the mortgagor his right to redeem the mortgage property, then that is definitely not suit for redemption. Then what is it going to be? There are two most important suits and two most important rights in TP Act, redemption and foreclosure. One rests with mortgagor and one rests with mortgagee. So the correct answer will be suit for foreclosure over here because it is debarring redemption. Section 67 of Transfer Property Act deals with foreclosure. So foreclosure का right किसके पास होता है? mortgagee के पास. अगर mortgage money टाइम आने पर या ड्यू होने पर भी मॉर्गेजर नहीं देता है, then his redemption right will get debarred and the mortgagee will get the right to sell or foreclose the particular mortgage. So he can file a suit for foreclosure. So this was all in the first part that I was going to cover from previous year paper. Now in the next video, that is the second part, I will be covering the remaining questions of this particular paper. Stay tuned to Legal Beat. For any queries, do reach out to us and prepare 50% faster with us at iExam.